G'day everyone, and welcome to the second video in week 3 of our legal ethics course. This week we're looking at admission, and in this video we'll look at the process of admission. How do you get from graduation day to admission day? The first thing to understand is that in general terms the court will ask 3 questions before an applicant can be admitted. Have they completed the prescribed legal education? Have they completed practical legal training? And are they a fit and proper person to be a legal practitioner? The first 2 are actually pretty straightforward. Either you've completed a priestly 11 degree or you haven't. Either you've completed one of the authorised practical legal training courses or alternatively the trainee solicitor scheme, or you haven't. The hard bit, and the bit that the admission process is focused on, is the question of whether a person is a fit and proper person. Now in the third video this week, we're going to look at the specifics of some of the pitfalls which may prevent you from being considered fit and proper, but they include things like bankruptcy, criminal offending, academic dishonesty while at university, accepting Centrelink overpayments, failing to vote. We'll look at those in detail. First though, I want to get you thinking about whether fit and proper is actually a helpful idea, and whether the law really has any business making personal judgments about people's moral fitness. I mean, for one thing, morality is a culturally contested idea. As recently as 1997, homosexuality was still unlawful in Tasmania. Heck, it was only decriminalised in Queensland in 1991. Justice Michael Kirby, who has been with his husband since 1969 and who was also a communist in his youth, would probably never have been admitted to practice if he had openly admitted to being gay. He would not have been considered fit and proper. The question of fit and proper hits Indigenous people extremely hard. Are we really going to say that a young person who grows up, say in Woorabinda or Arakoon, and who has a few brushes with the law in youth, but who then makes it through the system and ends up with a law degree, are we really going to say that that person's not fit and proper? What about a young person who aligns themselves with the Extinction Rebellion movement and who's arrested while literally trying to save the world? Do we say that their arrest causes them not to be fit and proper? The whole question is terribly complex and frankly a bit uncomfortable. But for better or worse, this is the system we've got. You have to be educated in law, you have to complete practical legal training, and you must be fit and proper. When you apply for admission, you're actually making an application to the Supreme Court. So in theory, it's just like an application for an injunction or an application for a declaration. It's an application for admission. So you'll be required to fill out an application, file it as an originating process in the Supreme Court of Queensland, and serve a copy on the Legal Profession Admission Board. So you're saying to the board, here I am, I've applied to be admitted, and you're on notice of that fact. The board, under Section 39 of the Legal Profession Act, is then required to make a recommendation about each application for admission. Now, assuming that everyone who applies has their LLB and their PLT covered off, really, the board is making a recommendation about whether each applicant is fit and proper. There are a number of steps they take in order to do this. First up, you're required to complete a great long form, and hidden away towards the back, you're required to state that you have considered all of the matters listed in Section 9 of the Legal Profession Act. That's a big old laundry list of factors affecting suitability for practice. Video 3 is all about those suitability factors. You're required to state that you're not aware of any matters that bear adversely on your suitability for practice, or alternatively, you're required to state that you are aware of such matters and then set them out. We'll talk about how in a moment. So that's the first step the board takes to assess whether you are fit and proper. They ask you. Next, you have to file 3 different versions of a form called Form 8. These are essentially referee forms. They can't be from near relatives. They have to have known you for at least 2 years, and one at least is supposed to be from a legal practitioner or a justice of the peace or a senior academic. So you need 3 people to vouch for the fact that you are a fit and proper person. Next, you need to complete a form declaring your intention to apply to become a legal practitioner, and then publish that form in the Queensland Law Reporter, which comes out electronically to the entire legal profession and anyone else who asks to get on the list once a week. So you're required to publicly declare to the whole world your intention to apply, and invite anyone who wants to object to your admission to come forward and do so. We're still not done. Next, you need to make an affidavit, which is a sworn statement, essentially the same as if you made that statement in the witness box. You have to set out anything in your history that might bear on your suitability for practice. When in doubt, set it out. Criminal offending, academic misconduct, speaking with your mouth full. Okay, maybe not speaking with your mouth full, but this is your chance to confess to the board whatever skeletons you have in the closet. It's your chance to explain what has happened in the time since then. It's your chance to put context around whatever it is that you have to disclose. It's your chance to show that something that you did in the past should not tarnish your reputation now. If you do this, the board can be surprisingly forgiving. Let me tell you about a couple of examples. First, let me introduce you to David Kang. In 1994, to protest the plight of Cambodian refugees, he stormed a stage with a pistol while Prince Charles was on the stage. It turned out to be a starter pistol, but nobody knew that. I'd love to show you the footage, but the ABC wanted to charge a ridiculous amount, more than $3,000, for me to use the material. For that money, the ABC can get stuffed, and you'll see the link in the description for this video. Go give it a look now. Now, you would think that what looked like on its face an attempt to assassinate the heir to the throne, you'd think that would make you not a fit and proper person. But to his credit, Mr. Kang served his sentence, studied the law, and he eventually became a barrister in Sydney, where he continues to serve the community and serve the law to this very day. And then there's Debbie Kilroy, who in the 1980s was married to Brisbane Broncos rugby league player Smokin' Joe Kilroy. Both of them were convicted of drug dealing in 1989. She served 3 years of hard time. When she got out, she established Sisters Inside, an advocacy group for women in prison. In 2003, she was admitted to the Order of Australia. In 2004, she was awarded the National Human Rights Medal. She trained as a social worker. She saw the law as part of the problem, so she studied it. And in 2007, she was admitted as a legal practitioner. So even if you have history, if you declare that history, own it, and show what has changed, you may well be admitted. The one thing the court will never overlook, though, never, is a failure to disclose. If you don't disclose some key aspect of your history and then it comes to light, nothing will save you. This happened in a case called OG, who colluded on an assignment at university and was awarded 0 marks as a result of that collusion. OG disclosed the 0 mark, but then lied about the circumstances. OG's admission was overturned. So thus far we have your statement that you're fit and proper, we have references from 3 referees, we have your public advertisement, and we have your affidavit. If the board has any concerns at all, it can undertake further investigations, and ultimately the board will either recommend or not recommend the admission of the applicant. Finally, your admission must be moved in actual court by another practitioner who's prepared to stand there on your behalf. So we have this multi-pronged approach to assessing whether an applicant is fit and proper. If you think about it though, none of this is really about proving that you're fit and proper. It's more about showing that you haven't specifically done anything that demonstrates you to be unfit or improper. It's not like the process asks how many old ladies you've helped across the road, or whether you've ever grown a mustache for Movember, or whether you floss. The focus is on whether you've done stuff wrong, not whether you've done stuff right. So in the next video, we're going to break down some of those forms of disentitling conduct to show you what sorts of ethical failings might prevent a person from practicing law in Queensland. We're halfway through week 3. See you in the next video.